All right. Hello again. This is Ben Hitchcock Cross talking to you today. I was pretty pumped up to get this Poway, or is it Pouchway? I'm still unclear. Number 2 going here. Just got news that Candy the goat died, so you were going to have to sit through a goat eulogy here. She is the last of my does from the original herd that I got in, I'm going to say 17, 18, something like that. The last, for sure. And she was not looking that good the last couple of days. I was not surprised. I mean, she's definitely older for a goat, but holy cow, that is the end of an era. Um, Now I sort of understand what they mean by replacement does. Um, but yeah, that goat was consistently awesome for years. And I mean, when I got her, she's at least almost 2. So pretty good. But nevertheless, I'm kind of decimated here. No, worse than that. Worse than that. Whatever the word is for like 55%. Jeez Louise. It's even hard to say it. There are, when you go to war with some of the largest employers in the state of Wisconsin, and apparently the Department of Workforce Development, there's going to be casualties, of course, but hey, all right, you came for the First Amendment and you're getting the goats. That's how this channel goes. Welcome, one and all. All right, that worked, so hooray. We are in Superior Court of California, San Diego. Keep that in mind. This is the Poway School District is the way that I read it. This is the lawyer up here. Redden seems to be the top person on there. I need to make a correction before we go any further. And if you just hold with me, I got to take care of a small matter. All right. The correction that I wanted to make was this. I got a headline confused. It appears that there is a settlement in this case, but that the terms of the settlement have not yet been disclosed. I confused, either on a Google search or something else, another California school district. That's the $27 million headline there. So that was that. Let's be clear on that. This is, though, a First Amendment claim, and it does seem to have been settled based on the news. I can also say there's a quote from Mr. Redden here saying that the entire administration needs to be dismantled and started over again. And here's the one thing that I want to say on this overall. We talked a lot about sort of the parenting power of the superintendent. I've had several clients come to me who are working in school districts as HR in particular, and they cannot believe what goes on in a school district. They are coming from a corporate environment to a school district environment, and this may shock you, but the school district environment is more authoritarian and more arbitrarily controlled than the corporate environment. There's more tyranny at the school level than there is at the corporate level, so say these clients. I'm guessing that they're, mid-level to larger level corporate, someplace with like a corporate headquarters kind of thing, but still. And many of them are like coming to, they're coming to help, and they're coming to, they've moved to a different area or so forth, or maybe they're moved back home like that. And man, that face, I've come to get used to it now, but the first time I heard that, you're like, a school district is worse than a corporation? Like, wow. So just keep that in mind. What I'm saying then, going back to Mr. Redden's comments here about the entire school district administration to basically be scrapped and start over again, my concern is this. There is a power structure in place at the school administration level that's like quasi military, I think is a good way to put it, much like the police department, the fire department, and sort of other levels of government are enacted. And whatever, I mean, I think there's a reason a lot of principals have military backgrounds. And I think that, I know that's becoming much more of a professional class, the principals, but meaning they're getting specialized education, and groups, and that's what's determining your principalship, not so much your other. We're not getting people coming back from the wars who are becoming principals as much, at least in my area. Okay, if you got a different experience, let me know. But the point here is that it's this authoritarian setup where your fate as a teacher, and you're basically this. I think that's one of the bigger things that people don't understand, is that unlike in a corporate setting, because of the small nature of schools and the locations and so forth, a principal, but a superintendent can more or less dictate whether or not a teacher, and very likely an administrator, can ever work in that job again, period, in the end. And I think that needs to be understood as to why many of these administrators are going to be enacting like a North Korean style purge, and it's that level of power. So that I think is something that needs to be, that's going to be the theme of today. Okay, enough of the headlines. Let's go to hopefully paragraph 56 somewhere in there. Thanks. I was getting Alice Delisle flashbacks here. If anybody knows, I'd be really interested, or wants to find out, I'd be really interested to know if these numbers, like the lines here, and the bolding everybody's names, if that's a rule or just a convention, or why do they do that in California? We just have paragraphs, which is what I've seen. I think it's kind of cool how they have their, we've seen their address, and they've got good free advertising here. I think that's more power to them. I know we couldn't put that on the side there. And I'm just saying, this is just as a normative fact here. Boy, I want to get back into this. I think even if we could put our names on the side, like there was no rule against it, Wisconsin being the kind of state that it is, somebody would be really uncool with it. All right. So let's try to remember that free speech, you need to have a free speech right, okay? That's pretty simple. You need to have somebody acting under the color of law to deprive you of your free speech rights, okay? The first box that you have to check there, obviously, that's sort of this like putting fire in a crowded building test. That's pretty simple, I would think, to understand. Is something free speech? Is it not free speech? Free speech takes many forms, but punching somebody in the face is, generally not considered free speech. So that's, I think, the first thing that we have to check, is because the students maintain free speech rights, limited free speech rights, because it's a quasi-military facility, I guess. But they have limited but still free speech rights at school. Okay, so you do have to, right? They can have rules that say no swearing, for example. Where the government couldn't impose those same kind of rules as you're walking down the street necessarily. Okay, they can have good order and decorum is they have to have some rule basis to that, but they can't say, for example, no Trump signs unless they say no political signs. And there's some variation on that. And these examples are all super fraught. Why? because one judge's free speech is another person's outrage. So that's that one. But the ordinary test, and something on ground that I feel much more comfortable on, is that somebody acting under the color, a person acting under the color of law to deprive you of a constitutional right. Okay? Um, there is often a lot of things about questions on the people comments about qualified immunity. That is fairly simple doctrine. I categorically agree that qualified immunity is preposterous. And there's many things that I did not care for Justice Scalia's approach on, but also this is something that I think he personally created out of thin air. I totally get the concept, and it's very similar to deliberate indifference as well. Basically, it kind of goes like this. There's a couple of different ways you can look at it. One way you can look at it is no harm, no, if they get a freebie, or they get as many freebies as they want until somebody actually takes it all the way to the Supreme Court. Okay, that's one way to look at it. Especially if you're the victim, that's probably how. Another way, and I think the way that the judges most closely identify with, is not so much the taxpayers, but the question of, do I want to be in a position of allowing the taxpayers to be on the hook for, a tremendous amount of money because of some dunderhead? That's really because they're going to assume that a board is full of a bunch of idiots, or can be full of a bunch of idiots, or at some point statistically is likely to be full of a bunch of morons who don't know what they're talking about, or etc. And I think the general reasoning behind, and we're going back to school law here, not qualified immunity, and I know there's parallels, that's why we're talking about it together, but I want to make that distinction. The reasoning for that is basically saying we don't really want to make all the taxpayers of a school district liable for the bad behavior of one junior varsity coach one time. Okay, and that really is what the deliberate indifference standard is. Basically, that junior varsity coach assaults somebody or does something to violate Title IX or whatever. Not whatever, but you see what I'm saying. Then the judges, then then the school board and the district, more importantly, is not going to be liable unless the plaintiff can show that they knew or should have known that this had already happened and was likely to happen again. Okay, so they're basically getting a free, which is a concept in tort law that's not it's not shocking. There's many examples of basically, a dangerous condition is a similar situation to that. I know we've talked about this before here, right? This is an icy condition and a situation, and that is a pretty good analogy here. Okay, freak cold snap. There is a place, and freak rainstorm followed by a freak cold snap. There is water pools in a place that it might not normally pool in. These are the facts that I'm laying out to you. And then it freezes. Okay? Now, Miss O'Leary goes walking by and she slips and falls and breaks her leg. Okay? Who's liable? Or more importantly, can she get money from the store that owns the area? Okay? Well, if you look at it under basically, did they have an opportunity to foresee that this would happen? Okay, so my number one question on this is going to be, as a plaintiff's attorney, is can I show whether or not this has happened before? Does it happen on a regular basis? Is this something? How are you going to show that they knew or should have known, right? And that we have that in employment law too, where, for example, sexual harassers are frequently do it before. But if you have a coworker, a non-supervisory employee who is straight up sexually even assaulting you, it's whatever. It to get the employer to be liable, they have to have either known about it or put them in such a situation that was obviously going to happen, which that's going to be tough. So you basically have to have some kind of evidence of them knowing of prior bad acts on his part. Okay? Now, unfortunately or fortunately, many, depending on how you look at it, many assaulters are repeat offenders. So it's actually very common for me to have repeat sexual assault. Somebody comes in and they've been sexually assaulted in the workplace, and with a very little, personal detective work, it's not hard to find out that employee has done it before. Okay, so we just made a bunch of parallels too. I'm clearly going to stop this video now. I'm sorry I got for the head up. We're going to go back and do another Poway from the beginning there, or from paragraph 58. Okay. But I just want to make those clear between qualified immunity to wrap this up. And basically, there has to be a Supreme Court precedent that states that this is what the Constitution says, that you can't do this. Okay? And sometimes that's pretty obvious, but sometimes it's not. Okay? That is that standard. Then we've got sort of the deliberate indifference, which is similar, but it's the same kind of concept. Really, is we're not going to make a whole corporate body responsible for the acts of just one employee unless the corporate body knew about it. Okay, if it's the superintendent, this is the supervisor, it's a different story. But so that when you can say a school district is deliberately indifferent is when they have known something, a condition exists, and basically the easy one on that is there is a sexual assault allegation or investigation finding that happens, and the school doesn't fire the person, and then that person does it again. The second time, they can be said to be deliberately indifferent to what has happened. And the third thing that we're talking about is respondeat superior, meaning making an employer liable for the acts of a coworker and what they need to have known ahead of time. So, slight divergence here, but otherwise we'll be on like 2 hours for the next video, so we'll keep that shorter. But there we are with that, and of course a goat eulogy. She's a good goat. Take care, guys. Really good mom, too. Damn.